Good afternoon, everyone. It's a pleasure to have you joining us in this last event of the Advanced Topics on Seminars that we are organizing with Instituto de Investigaciones Jurídicas de la UNAM, the University of Aberdeen, and the Arbitration Center of Mexico. It is my pleasure to welcome you to this definitely very interesting and very modern session in which we have the great pleasure to have the participation of outstanding practitioners internationally. So I hope we all make the most of this session. I remember you that we all can ask the question to our panelists through the chat. And honestly, we shouldn't miss the opportunity to have this dialogue with experts of international arbitration in the world. Now I ask my colleague, Ana, for continuing the session.
Thank you, everyone. Muchas gracias por acompañarnos. Like we told you in advance that this session was going to be held in English so that we could invite our international speakers. And first, I want to tell you that we invited Dr. Patricia Shikovic. I hope I said that right. To help us to moderate this session, since she's a lecturer in dispute resolution at the School of Law at the University of Aberdeen. And she also teaches international commercial arbitration, negotiations, private international law, international sale, and IT law courses. She's a member of several committees, the committee of the Northern Chapter of the Scottish branch of the CIIARB, of the Scottish Universities Dispute Resolution Network, and the Scottish Law and Nation and Innovation Network. So Patricia is going to help us with the moderation for this session. And now let me introduce our three main speakers. First, we have Nusha Basiri. She attended the Universities of Cologne and Barcelona. She's admitted to the Cologne Bar and is a member of the Brussels Bar. Nusha holds German and Iranian nationalities. She's a native German and Farsi speaker. She has a solid record as counsel and arbitrator in numerous international arbitrations under the major arbitral institutions and arbitration rules and governed by various procedural and substantive law. She's an expert in different types of topics, multiple sectors like banking, construction, energy, finance, infrastructure, insurance, luxury, maritime equipment, etc. She's praised in Who's Who Legal Arbitration. Since 2018, is acknowledged as a top leader on arbitration. Next, let me introduce to you to Claire Morrell. Claire Morrell is a dual qualified arbitration practitioner admitted to practice law in England and Wales and the US as well, the New York Bar. And she has acted as counsel in proceedings conducted under the rules of different arbitration institutions, as well as ad hoc proceedings, and involving different laws, including England, Wales, New York, Texas, France, Sweden, etc. And she has particular experience in disputes relating to technology, corporate transactions, license, cross-border sales, and her practice covers industries such as IT, engineering, commodities, etc. She has also been recognized in Who's Who's Legal as a future leader in international arbitration already for several years. And we also invited a Mexican star of the arbitration, Omar Guerrero. He graduated top of his class, summa cum laude, and he holds 3 postgraduate degrees, including an LLM from LSE with merits. He has advised companies in different sectors as well: pharmaceutical, hospitality, telecom, food, construction, IT, and agro-business industries to advance their business objectives. And he has also acted as arbitrator in domestic and international disputes, where he sits deciding cases which he's entrusted. So thank you so much to our guest speakers of today for agreeing to talk with us. And now let me leave you with Patricia, who is going to help us with the moderation.
Thank you, Ana. I would like to thank you and Gloria and Sylvia for inviting me today to moderate. This is a very interesting topic that combines 2 of my biggest interests in research and teaching, which is dispute resolution, specifically arbitration and technology. I'm also, it's a honor and a pleasure to be in presence of such distinguished practitioners and colleagues in the panel, and I'm very much looking forward to the discussion. Before we start with the discussion, I would like to introduce our audience to sort of a structure that we have designed for today to make the discussion quite dynamic as possible so that they enjoy it as much as possible as well. The discussion today deals, probably as everybody here knows, with one of the hottest topics in 2020, and that is the use of technology in arbitration. We have split the discussion in 3 parts. The first part will deal with the legal framework for the use of technology in arbitration, platforms, and preparation, for example, for a virtual hearing. The second part will address due process issues that might arise when we use technology in arbitration. And finally, the third part, probably the most visionary part of today's discussion, will deal with the use of artificial intelligence in arbitration and provide us with a look into the future of arbitration as dispute resolution mechanism. Without further ado, I would like to open the first topic of today's discussion and give the floor to our panelists. And if you all agree, the first question for today goes to Nusha to help us define the legal framework for the use of technology in arbitration.
Muchas gracias, Patricia, y encantada de estar aquí con os. I think that's more than enough for my Spanish tonight, but because you mentioned, Ana, that I studied in Barcelona, I didn't want to disappoint you, although it is over, thank you for the claps, although it is over 25 years ago. It's a pleasure to be with you, and it's my pleasure also to give you an overall view about the current legal framework that is at hand for us arbitration enthusiasts and practitioners and academics about the legal framework for the use of technology in general in arbitration. I will not so much focus on virtual or remote hearings. That's for a little bit later. But for the time being, I think it suffices to say or to remind ourselves how we get to an arbitration, obviously, and that is through the arbitration agreement. So if we look at the legal framework, that's the first place we have to look at the arbitration agreement. And it doesn't happen that often that parties actually do explicitly refer to the use of technology that should be permitted pending the arbitration. But obviously, what they do very often is in institutional arbitration clauses to refer to arbitration rules of various institutions. And actually, most of the arbitration rules of institutions have provisions for the use of technology in the framework of the arbitration. That doesn't come as a surprise. We're in the year 2020, soon turning to the year 21. So, of course, we are using technology already for decades. Now, the problem is only that, or it's not a problem, but the lack of the use of technology that is expressly mentioned is when we look at the law. And we won't find so many laws that explicitly refer to the use of technology in arbitrations. We have, modern laws should do that, but we have also, of course, a lot of UNCITRAL model law countries, and they have not yet maybe developed, and they have not ultra-modern UNCITRAL model law countries included explicitly in their laws that arbitration can be conducted by means of technology. So while that is a little bit lagging behind, we do have, as example, a couple of laws that I can provide you with. For example, the Dutch arbitration law and Article 1072b provides for the use of technology in arbitration proceedings. The Article 28.2b of the UAE federal law, number 6 of 2018, same thing, provides for the use of technology. And as well, from that same year, Article 17b and 21 of the Jordanian law. So you see the younger the laws, the more the actually consideration of the legislators to include explicitly the use of technology in the arbitration law. The Dutch Arbitration Act is from 2015, if I'm not mistaken, so it's all within the last couple of years. Now, where does this bring us? That brings us still to the possibility to use technology in arbitration, obviously, even if there is no provision in the specific arbitration law at the seat of the arbitration, because in a lot of the rules, or if we even look at Untitled model, the Untitled model law, we have Article 19(2), which provides that failing such agreement by the parties, the arbitral tribunal may, subject to the provisions of this law, conduct the arbitration in such manner as it considers appropriate. The power conferred upon the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. This provision is turned into many rules to give the tribunal to conduct the proceedings in an efficient and smooth manner, and then also to conduct the arbitration in a manner that it considers appropriate. And that is, of course, by using technology. So all to say that even if there is no provision in the law that you may use technology in an arbitration, you have institutional arbitration, then you are helped out with. But even if not, it is within, I suggest, the powers of the tribunal to conduct the proceedings in an appropriate manner that is time and cost efficient, and so with that also actually the use of technology. Now, there is another point that I would like to make here as well, and that is, in my view, separate, but should nonetheless be mentioned as well. We have in many laws, and I think also in the Mexican arbitration law, I should actually not say anything about that here in front of the experts. Yes, though we have it in Article 1423 of the Mexican Commerce Code. The agreement arbitration shall be recorded in writing and shall be entered in a document signed by or in an exchange of letters, telex, telegrams, facsimile, or other means of telecommunication. So you see where I want to go to. I want to go to the arbitration agreement as such. That in many laws can be also put and exchanged by technology, be it now telex is outdated, obviously, but facsimile or any other means of telecommunications. But that is only for the arbitration agreement, and that is, in my view, not connected to the point about using technology and arbitration. I just wanted to mention that as an extra point as well.
Thank you so much, Nusha, for this extensive overview. It's really good to know that new laws are envisioning this possibility. I would like to ask Omar to help us narrow down the question even more, especially having in mind, Nusha mentioned 2020 developments as well. Do you have any knowledge on how did the Mexican arbitration community react to the adoption of technology in arbitration due to COVID-19, especially having in mind emerging practices? We have seen that all over the world. Institutions reacted with protocols, with guidance, and so on. Do you have any insight? How did the Mexican arbitration community react?
Thank you very much for asking and raising this question. I will say that three words will define how Mexican practitioners, arbitrators, and arbitral institutions have reacted. The first one will be adaptation. The arbitral community in Mexico, I think, quickly adapted to the new challenges, taking into account the most or the most important and best practices in the subject worldwide. That includes, of course, not only what Nusha mentioned regarding the possibility for entering into agreements through electronic means, but also the possibility to immediately adapt and accelerate the pace to hold remote hearings. The second word will be acceleration. All of a sudden, I think we live in a new world whereby the name of the game is flexibility, adaptation, and acceleration to be in the pace of the new challenges. And the third one will be probably reinvention. I think I consider myself like a dinosaur with certain technologies. I am 50, but all of a sudden, when I thought that I was slowly adapting myself to the new practices, etc., then we have to embed and enter into this kind of challenge immediately. I think the arbitration community, both in the arbitration and the party council community, adapted quickly. That means that even though in the past we had pre-hearing conferences or the management conference through electronic means, now I think it is well established so far that you are able to hold remote hearings and even to have discussions with your arbitrators through this kind of Zoom conferences, WebEx, Cisco, or any other platforms that you have. Now, I think the important question will come whenever there will be challenges to the awards that are going to be rendered and how the Mexican judiciary is going to react. Mexico, as any other Latin American country, is well known for the excessive weight that sometimes put in formalistic issues. And therefore, I think the judiciary should be prepared in order to uphold the kind of proceedings and decisions that are going to be taken through these means or technology means. For instance, and I think we're going to discuss later on this, whether or not the fact that we are not having immediate presence, but rather remote virtual hearings will be an undermining to the right to present your case. My guess is that the Mexican judiciary is going to react well, especially because we have our courts closed for almost 5 months, and all of a sudden they change and adapt in order to have again, and I'm sorry, for the court proceedings, virtual and remote hearings. And then my prediction will be that exceptionally we should have a problem with this kind of virtual and remote hearings and the use of technology that it seems to be the new rule of the game. What I will expect, of course, as well, is that the Mexican arbitration institutions will react also probably by adapting their arbitration rules. The Centro of Arbitraje de México, CAM, is very well known in Mexico. It's a star in the administering of arbitration proceedings. I will expect that they will adapt with these new challenges, as well as Canaco, Mexican Commercial Chamber, will adapt itself as well in order probably to resemble what the ICC and London Court of International Arbitration rules say. But that's what I will say, just to finalize, is that I see that the Mexican arbitration community will basically keep on using the best practices for this kind of proceedings. Thank you, Patricia.
Thank you, Omar. That's indeed good news from the Mexican arbitration community. Hopefully discussions like this will highlight the issues that are to be taken into account later on by courts and also arbitral institutions when redesigning their rules. To make the discussion even more sort of molecular at this point, before we go in depth on due process later on, I would like to ask Claire if she's aware of any laws that are regulating not the whole procedure to be conducted through technology, but certain elements such as virtual hearings or document production or any type of evidence production, for example, witnesses and experts who can actually participate remotely. And specifically, if you're aware of any laws or rules that are forbidding it explicitly.
Hi, thank you, Patricia, and thank you to all the organizers for the kind invitation. I'm very happy to be with all of you today. So no, the answer to your question is no. I'm not aware of any arbitration regime that forbids the use of technology generally and virtual hearings or remote hearings. In fact, I think maybe we should start by saying that remote hearings have been used for a long time, well before the pandemic struck. It was very common. It's been common, I guess, for around maybe 10, 15, 20 years to have witnesses, or one witness, two witnesses, an expert taking part in a hearing remotely. Issues at that time, in my knowledge or experience, were not raised. I think what was new this year for all of us was that everyone would take part in the hearing on a remote basis. And so we were effectively in presence of arbitration regimes. So, and I'm counting here arbitration laws, statutes, codes of civil procedures, and arbitration rules, and even, frankly, soft law. This whole body, I haven't checked all of them, but generally does not expressly either allow or forbids remote hearings. Most regimes talk about hearings. Most regimes do not talk about in-person hearings. I wanted to make an analogy here with deliberations. Most rules on deliberations do not talk about remote deliberations or virtual deliberations or in-person deliberations. And again, deliberations have been going on remotely for a long time, well before the pandemic struck. Although I'm aware of one law, I believe that the law of arbitration in Italy used to require that deliberations take place in person, but that's no longer the case, as I understand. But just to say that effectively there is no express right to have an in-person hearing. Generally, there is no right to have a remote hearing, and there's no prohibition. So what I think, it doesn't mean that you don't have a framework. It just means that the legal framework is the one we know, and we just fall back effectively on this. It is this kind of fallback position where we say arbitrators have the power to conduct the case in the best way, an efficient manner, and also giving a fair, depending on the jurisdiction, making sure that there is a fair or reasonable opportunity for the parties to present their case. And I think this is the starting point. And from that, what we've seen in the summer and since the spring actually is effectively tribunals grappling with this issue based on the circumstances. So yes, no regulation, power. Full power to decide on that. And generally, I would say it's very much just an issue of a case-by-case analysis. Similarly than technology, I mean, the use of technology, being able to allow to use technology in arbitration will not necessarily mean you can have a remote hearing, will not necessarily mean you can use artificial intelligence to identify responsive documents, right? So I think, we're bound to ultimately, and probably move on to that soon, is to talk about the specifics here. And before we do that, I wanted to say two things. One, that the institutions have started to revise their rules to specifically address that point. So I wanted to give an example with the LCI, the new 2020 LCI rules, which have been revised, and that's Article 12.2 of the rules, which now specifically says that hearings can take place remotely. So that's one trend. And I also wanted to mention the decision of the Austrian Supreme Court that came out on the 23rd of July this year, which, again, it's not a regulation, but I think it will provide some guidance to arbitrators and also potentially also national judges who will have to grapple with that issue as part of challenges to arbitrators, challenges to awards, and also enforcement proceedings.
Thank you, Claire. If I understood all three of you correctly, we are dealing with a non-existent maybe framework, but permissive in any case. So with that in mind, I would like to move forward. And I think for this round of questions, we can spend a couple of minutes discussing the practicalities before we move to due process issues. So I would like to talk about and ask you about the potential platforms that can be used and technology in arbitration. If Claire, we can continue with you. If you could just tell us if there are any preferences or at least trends when it comes to specific platforms that are being used for arbitration.
Start with distinguishing two things. So platforms for virtual hearings is one type of platform. There is, on the other hand, also platforms for case management. So both of those platforms have been used for a while. I think one of the trends that we're going to see is to see more and more platforms that provide a comprehensive service. And so I think we're going to see platforms that provide, an ability to file documents, share documents, but also conduct virtual hearings. Of course, when the pandemic struck with the beginning of the remote working, restrictions and policies, we had to adapt very quickly. I think around that time, the focus of the discussion was around security, so cybersecurity. I know, for example, that Zoom security has increased even, while the pandemic, and the current environment was evolving. I'm not aware, unfortunately, of data about which platform is used more often. For obviously confidentiality reasons, this data is not available. But I know, for example, that Zoom is often used nowadays. When, interestingly, I think at the beginning, I think Zoom was the one where potentially there was the most concerns with. In terms of more comprehensive platforms and case management platforms, we cannot not mention the SCC platform. I think where the SCC has been extremely innovative with their platform being, I think maybe after the AAA and ICSID having built that platform and actually decided to make that platform available even for non-SCC cases during the pandemic. I think it's important to understand, how broad those platforms can be when it comes to making a choice. Because your questions to me was, what are they? How can one select the best platform for a case? I think there's different aspects to a case that those platforms can handle. The first one is administration, everything to do with filing pleadings, paying advances on cost, and potentially things like notification of awards, which has been quite a big deal in the pandemic when arbitrators didn't know how to sign the awards and institutions were not sure if they could notify by email. Another aspect is written communications. Now, it kind of goes without saying, you guess that it has to cover communications between the parties and tribunals, etc. I think one of the things that sometimes people have overlooked is that, do you want to really cover all the different flows of communication? So, for example, are you happy for the arbitrators to deliberate on the same platforms used by the parties? I mean, if it's all well set up, that there shouldn't be any problem. But I think sometimes people have focused too much on communication between parties and arbitrators, and not so much, for example, on communication between arbitrators, which arguably is even more high risk due to the confidentiality of the deliberations, and also communication between members of the secretariat of an organization and member of a court. So if you think about scrutiny of awards, for example, members of those for example, the ICC courts will have access to those draft awards. So we need to make sure that those platforms are comprehensive. So that's the second aspect. The third aspect is documents. Some platforms are also available for document production, document review, etc. That's potentially something you'd want to have added on to the rest. And then comes oral communication. So typically, Zoom or the similar. It's not only for hearings, but also for meetings. So what is that? What is the platform that you use for that? Again, do you use the same as the one that you use for documents or a separate one? I just wanted to mention the protocol for online case management in international arbitration, which is a protocol that some law firms have come up with, and I think it's quite a helpful document when it comes to selecting a platform.
Thank you, Claire. Definitely a lot to think about when choosing the platform, and many factors that you mentioned really need to be taken into account, especially if parties are considering different platforms for different parts of the pleadings, and something that everybody in the community needs to start to think about, especially law firms offering the service in the first place, how to advise the clients. You've mentioned different types of platforms, so I would like to invite Nusha if she has any view on whether it's better, not focusing so much on the factors that Claire mentioned, meaning the elements of the proceedings, but would you prefer choosing an external platform, or, as Claire mentioned, institutional platforms such as the SEC has, or a private platform such as Zoom that improved in the past few months incredibly? What would be your leading thought in considering these three types of platforms?
Thank you, Patricia. And also many thanks to Claire for this very excellent overview. I give you a typical, unfortunately, lawyer's answer, because it depends on the case and it depends very much on the players. So from my own experience, I can advise you that I have had experience with all three versions. So an external and an institutional and even a free platform, because I was also involved in three different cases in terms of volume, in terms of who is involved actually. Do we have witnesses? Do we have fact witnesses? Do we have expert witnesses? How many do we have? And I cannot tell you, and I'm not going to advertise any of them here, I cannot tell you what is better, because it really has to fit the actual hearing. And what I only would say is that for a hearing, so let's say a normal procedural hearing, I would say you go with Zoom, WebEx, or Teams, whatever you have there at hand for free, or for a very minimum amount. But even if you have a hearing with oral pleadings, but not witnesses, Zoom is perfectly fine as well. In fact, Zoom is also perfectly fine when you have witnesses. It just becomes a little bit more complicated when you have massive amount of documents that are being showed around and produced for a witness to look at. And so when you have this very, I would say, like 1 week-long hearing, where you definitely will have a lot of witness testimony. And I think for those ones, then indeed the compilation of these platforms that also do document management are quite helpful indeed, because no matter what, on the side of the parties, what you need to have is always also a document manager on your own team, and it can be a person with a legal background. It can also be a person with a technical background, as long as that person knows where to find the document that the lawyer now wants to present in the hearing. And so that is, I think, very key. No matter whether there is a fully equipped platform or not, or whether you're using a Zoom provider. So I think it comes down to the organization of your own team as well, and that depends on as well, obviously, then on the type of arbitration, length of the hearing, which platform to use.
Thank you, Nusha. Definitely a lot of food for thought, both from you and Claire. We've heard many considerations that need to be taken into account when choosing the platform. And now going back to Omar, a bit challenging question, I think, after everything we have heard. But to respond in bullet points, if you could just give us an overview of what do you think, taking all of this into account, how best to prepare counsels and parties for an online arbitration or virtual arbitration, or more specifically virtual hearing, if you like.
Certainly. I believe it is going to be important to have, and now more important than ever, to have a pre-conference and pre-hearing conference very detailed, whereby the parties and the arbitrators could agree in a protocol for the virtual hearings. I think it's a joint liability, joint responsibility for the good management of the hearing to have that discussion. And there are a few items that I believe are common to ensure an adequate hearing for the parties. One, and you mentioned before, the determination. That includes, of course, the possibility for having privacy, data, and cybersecurity issues duly controlled and duly acknowledged. Of course, what will be the time zones of the parties that are going to be involved? That's going to be important, because you don't want, at the end of the hearing, to have some sort of claim or warning that the parties were undermining their rights to address properly the hearing. I think more than ever, it's necessary not only to have a secretary of the tribunal, but also someone or a team that will ensure that the technical specificities are going to be covered. In that regard, that will include, of course, how you are going to manage the hearing bundles, how much in advance, how long in advance are going to be provided. Of course, even when we have these physical presence hearings, we wanted to use, and we were using basically data rooms, virtual rooms, and so on and so forth. But now it will be much more important when handling a remote hearing, how are going to be presented, what order, etc. List of attendees, seating plan, hearing agenda, and of course, how the parties, some sort of online protocol of how the parties are going to intervene, object, etc., are going to be important. Because just put as an example, this conference that we are basically holding right now, if all of a sudden everyone starts talking, there will be difficult for the transcripts or the recording to be properly assessed. What will be, or what will it happen with the breaks? Will it be with virtual breakout rooms? It will be basically to close partially the hearing and restart afterwards. The permissibility or not to have some sort of interaction between the parties. Just recently, I heard of Mexican hearing, arbitration hearing that happened, that one of the parties basically left open the microphone, and basically they were basically saying certain undermining things that were heard by the arbitrators and opposite counsel. Those kind of things should be basically diminished in order to have a good hearing. For instance, how you are going to cross-examine witnesses. How, and of course, we're going to talk about authenticity of the witnesses and so on and so forth. But is it going to be possible to have hot tubing, for instance, for expert witnesses or not? Interpretation, how you are going to present as well demonstratives, PowerPoint, presses, or similar kind of materials. Are we going to have transcripts or only recordings? And of course, I believe, and just as I started, it's going to be an art and a technical art how to address these kind of questions. By the way, I believe for these issues, there is an extraordinary recent book by Nusha Maxisher that I also admire her very much. I will strongly recommend for the attendees to buy it and read it, because I think it provides a very good background in all these issues. Thank you, Patricia.
Thank you, Omar. Definitely adding up on the pile of factors that need to be taken into account and contemplated well in advance by counsels and the parties when they are conducting proceedings in a different form, such as virtual proceedings. I would like to use all that you have said so far as a segue to our next topic, which is technology and due process, or the use of technology in arbitration and due process issues. So far, we have discussed best case scenarios where counsels and parties think in advance. They have the opportunity to hire, to choose the platform adequately, where the proceedings are running smoothly, where there is no complaint whatsoever on any side. And I think we are all very, very much aware, and we have mentioned that at the stage of the enforcement, this is usually no longer a case, but each party is trying to use any procedural irregularity to attack the award that they are not happy with. So if we can just move to the next topic and deal with which a bit more complex questions. And I would like to start with Nusha, if you don't mind. If you could just tell us how to handle situations in which we have technological imbalances between the parties. For example, higher costs that one of the party cannot afford, poor internet connection, unavailability, or lack of experience with the technology, because we are not all necessarily tech savvy. How to deal with that, and to what extent is that a due process issue?
Yeah, that's tricky. So first of all, imbalances can exist, and they do exist from the beginning. But I would say that most of the technical imbalances can be solved one way or the other. And I give you a couple of examples. But before that, I just want to mention at least one point about higher costs. Now, we're in a virtual setting here. As much as I would have loved to be in Mexico City, I am not there, but at the same time, I or my firm were saving also a couple of $1,000 by me not traveling to Mexico City and staying over. So the virtual hearing is, I think, a lot less cheaper, no matter what the equipment is, than actually going to the factual, physical hearing where we meet all physically in one room. So that's why I have a little bit of a split mind about statements made that it's so much higher for me than the other side. Of course, that needs to be taken into account by the tribunal. And the point that I want to say about the solutions to imbalance of technology is, well, if it doesn't come down to bandwidth, which actually it does come down to. Then you can find solutions by, for example, the one side actually buying maybe tablets or equipment and lending it to the other side's team, and then after the hearing is over, you ship it over then, or you ship it back then to the other side. There are also a lot of law firms that have their own sophisticated platforms. They're developing them as well, and so one can also make use of that in order to lower the cost if that's necessary. Then the poor internet connection, I think that, as I said, bandwidth as well, I think that can be solved one way, not to use Wi-Fi at all, but to use Ethernet, and in any event also to have a device with a 4G next to you as well. Again, if you don't have it yourself on your side, it can be managed that the other side would actually then lend it, and you can borrow it from the other side, and after the hearing then send it back again. It's not ideal, but it's definitely better to have the hearing, because what is the alternative? The alternative is not to have the hearing at all right now virtually, and to have it postponed then to a later time. And we have seen this year that we have to be really, really patient. We are tested with our patients, and whereas at the beginning of the year, virtual hearings were cancelled or postponed to the autumn, it became very clear that they cannot take place in autumn either in the way that it was foreseen or hoped for. So there are these imbalances. And of course, the due process factor is then the right to be heard, right to defend oneself, and the equal treatment in particular issue as well. But to overcome that with these practical solutions, and there are many more, I only pinpointed some of them. To overcome that, I think we have to come back again to the tribunal's power that we discussed earlier about using technology or having virtual hearings, and what this tribunal's power is. And it depends. I mean, we heard that there is really no law that specifically prohibits virtual hearings, and so there is this power of the tribunal to actually nonetheless say this is the mandate of the tribunal to conduct the proceedings, and we are now going forward with this even against the wish of one of the parties that would precisely come up with the arguments that there would be an unequal treatment. This is ordinary due process consideration on the side of the tribunal, and the case that Claire was referring to actually ended up in challenging the arbitrators, not the award, the arbitrators. And it was a very clear signal that the Supreme Court of Austria gave. And in fact, the same signal, although in an obiter dictum, was also given by the Cour de Cassation of Egypt. So I'm curious to hear what Omar will say about this, but I find it very difficult to actually take the practical hurdles and to turn them into procedural hurdles and to derail an arbitration or to successfully challenge a tribunal. We will see more cases, I'm sure. There's no doubt about it, but it depends, of course, once the awards are out, and whether then at that time a losing party would actually would refer to holding a virtual hearing against its will, then as a due process point.
Thank you, Nusha. That's very well put. I believe as much as your point of view sort of is good news for all of us, that we should not worry that much, or that we already have practice from which we can borrow. It's very good that we are talking about it today, sort of that we are ready when these objections are raised to know how to react. And I'm, as much as you are, interested in what Omar has to say on the same topic and whether he considers technological disadvantages a solid ground for due process violation, and if yes, in which circumstances, or if not, on which grounds as well. Omar?
Certainly, Patricia, thank you. One item that I believe it has become a good practice for our firm, and I believe it is for other firms that are devoted to commercial and international commercial arbitration, is basically to sign some sort of joint agreement with the other party, whereby the parties accept, one, that video conferencing constitutes a good means in order to hold a hearing. Two, that they agreed that the use of that video conference is the proper way, an adequate way in accordance with the circumstances. And third, there is also a statement or waiver that no party will seek to vacate the award or to refuse for the recognition and enforcement of the award due to this specific circumstance. In our experiences, those joint agreements have been executed by the parties, and that, in a way, I think it's well received in case that there is a challenge through the judiciary. Now, let's say that there is no joint agreement, or simply the parties did not basically put it. I think in order to assess whether or not that's going to be a proper ground to vacate the award or to have this lack of due process, we will need to analyze whether or not within the arbitration clause there was some sort of limitation as to whether there was an express exclusion of the possibility to have that remote hearing, or even if there is permission, the arbitration tribunal for some reason believes that it is not the proper way to do it, or if one party opposes to the possibility for holding that remote hearing. I will concur, basically, of course, context is everything under the circumstances. It depends on very much of the circumstances that we are going to be dealing with. But I will incline at the beginning that technology is a means, it's not an end of itself, and therefore it's a way, as Nusha put it, to be able to hold a hearing that's necessary for basically deciding the case. If there is some sort of opposition, that I will hope that it does not happen that frequently, I believe that the powers that are vested within the arbitration tribunal to conduct in an appropriate way, speedy way, the proceedings will somehow surpass or overcome those specific challenges to oppose to that virtual hearing, unless, of course, there are vital grounds in order to assess whether that possibility should be basically eliminated for the time being. The London Court of International Arbitration, the ICC, have strengthened the rules in order to allow those kind of hearings. Of course, at least in Mexico, the Lex Arbitri, the Mexican arbitration legislation, does not prohibit or limit that possibility anyway. And I will say that the judiciary, through binding precedents, the Mexican Supreme Court, provides that lack of due process is basically when you are not properly served, or you were not able to submit evidence, or you were not able to provide your closing arguments within the proceedings, or you were not able to receive a grounded decision in the case of merit. Then I will say that it will have to be for very specific limiting circumstances whereby the rights of one of the parties were absolutely undermined, and therefore they were not able to put or present their case properly. But my expectation will be for the judiciary to be very open to analyze the context, specific circumstances of the case at hand before making a rule that holding this kind of hearings will be a limitation of the due process right that you have. Now, as mentioned before, the Mexican judiciary, both at the federal and local level, have basically improved and enhanced rules lately in order to try to be more tech savvy. And therefore, the Mexican judiciary now is much more aware of the importance of holding this kind of hearings, since otherwise justice and the possibility to decide disputes will be seriously limited.
Thank you, Omar. I'm happy you mentioned also judiciary and that they are moving in the same direction, and arbitration, sort of a daughter of judicial process, should probably be even more progressive in that sense. I think we are all quite on a positive note, but maybe under some umbrella of proceed with caution, because of course we have never dealt with this many virtual hearings or virtual arbitrations. Now, if I may ask Claire, just to focus more specifically or practically on what institutions have already done in terms of, or any other development, it doesn't need to be institutional, to tackle some of these issues, and have they done anything sort of for our audience to have a good overview of what has already been done to tackle some of the issues that Omar and Nusha mentioned.
Thank you, Patricia. I mentioned earlier the trend, which is for arbitral institutions to revise their rules to be a bit more specific on what's allowed and what's not. I think this will provide certainty, but it will not remove all risks. Why? Because I think one of the lessons of the decision of the Supreme Court of Austria is that if you want to challenge on the basis of due process and effectively say that the award, or in that case it was the arbitrators, but let's say the award is invalid because one of the parties was not given a reasonable or a fair opportunity to present their case, it's always going to have to be specific. The court of Austria reiterated that, but it's effectively the case in virtually all arbitration regimes, that not only you've got to be specific and explain why due process was violated, but also you have to show that this actually had an impact on the administration of justice. It's all well and good to say you haven't managed to do that, but if you managed to do that, the case would have been decided differently. It's another animal. So they've done that, and I think it's a welcome development. There are also a series of sets of guidelines that have been issued by arbitral institutions and also international bodies. So generally, in relation to technology, I cannot not mention the work of the ICC Commission on Arbitration and ADR. They have, I think, a number of times now, I think 3 times, and the new edition is being worked on, a report on the use of technology in arbitration. I think the IBA also has some material, some guidelines on the use of arbitration, of technology in arbitration, with virtual hearings specifically. Again, there's a series of protocols. Just to quote a few: the Seoul Protocol on Video Conferencing in International Arbitration, the CARB Guidance Note on Remote Dispute Resolution Proceedings, also the Africa Arbitration Academy's Protocol on Virtual Hearings in Africa. So those documents generally will help, because they will identify potential solutions and considerations that one should keep in mind, particularly when sitting as an arbitrator. But again, they will not resolve the due process issues, in my view. Why? Because due process, as Nusha said at the start of this discussion, what we're faced with here is general due process considerations. there is a technology element to it, a virtual hearing element to it. But at the end of the day, what we're discussing is practically what happened and what was the impact on the proceedings and the award. And by definition, this will have to be decided on a case-by-case basis. I wanted to come back to what has been said. There was a comment made about potential the possibility to have parties agree that they will not seek to vacate the award on the basis that the hearing was held remotely. I agree, it's a good idea, but if there is a disagreement in the first place, you're not going to be able to obtain that. I also agree that ultimately, most problems can be resolved, and I think what the main issue here at the moment is uncertainty. We probably all agree that challenges most of them will be unsuccessful later on. The problem is that explaining to a client that you might have to go through a challenge or enforcement proceedings on that basis, I think is an issue, and there's nothing we can do about it apart from having a little bit more certainty in the rules. But I think in relation to virtual hearings, for example, institutions cannot say more. I mean, they can say that virtual hearing is fine, but they're not going to be able to regulate due process and technology in virtual hearings more. Because why? Because we want flexibility. Arbitration is chosen as a method of conflict resolution for its flexibility. So I think it's kind of a circular problem. We're always going to be back to the specifics. And arbitrators will have to, be courageous enough to make decisions at some point, and potentially judges too later on. But definitely something to keep in mind, I think, for our own practices when it comes to advising clients on risks, and also as arbitrators. I wanted to finish maybe with an example of. That Nisha mentioned earlier, that the Wi-Fi connection quality can be solved. I wonder if there are going to be examples of hearings or awards being challenged with due process issues where potentially the impact on due process was not identified at the time. And I wanted to actually pick up on that example. Actually, in Nisha's book, there is a very interesting reference to a study that was made, I think, in Germany in 2014 about the impact that a delay in conferencing on how the person who's taking part in this conference is perceived. And apparently, only 1.2, I think, seconds delay when a person speaks. If there's a 1.2 second delay, this can have a significant impact on how the person is perceived, and the person can be perceived as unfriendly and non-responsive, for example. So I think an interesting issue, which I wouldn't be surprised that would be raised a lot. Again, at the time it's raised, if you see it as an arbitrator, you might think, well, this is a dealing tactic. They're just trying to be difficult. No matter, the underlying reason why that's raised, you have to rule on it. And it's a difficult position to be as an arbitrator, because you have effectively very little grounds and provisions and law really to relate to. So you have to come up with your own sense, and I think that requires courage. I've been in this situation over the summer, and that was difficult. And frankly, at that time, whether it's raised as a dealing tactic or not, it doesn't matter. You still have to come up with a very tight procedural order, because there is a chance that this will be a problem later on.
Thank you, Claire. I'm so happy that you already mentioned the topic of psychology, sort of in advising clients, but also how to react to the use of technology, because after all, we are humans using the technology, and we can lose a lot in communication and come to wrong conclusions in the end. Being very mindful of the time that we have left, I would like to suggest the following. We already talked a little bit, Claire mentioned the psychology and communication, and I would like to pick a question from audience on this topic and then proceed with evidence and oral hearing, which would be structured again around the questions we got from the audience on cybersecurity and confidentiality, and then how to deal with the with proving that documents are authentic and also witness testimony together. Again, I would like to invite panelists just to try to be as brief as possible. We are all lawyers, but just let's try to address also the last topic before the end. And of course, please, for the audience, write down your questions in the chat and I will pick it up as we go. So the question that dealt with the communication came from Fernando. The question is, do you think that the absence of the physical contact would change the results and analysis of the claims as it is argued by some scholars? If anyone would like to volunteer to address this, it does deal with communication and psychology of lawyers in arbitration.
I make it very brief. I don't think it will change the analysis of a claim. That's quite far, I would say, as a consequence. But it is true that the psychology is different. We could call it Zoom fatigue or Vicon fatigue or whatever you want to say, however you want to mention it. It's one thing there. The other thing is that you're remote from, you as a lawyer, as a counsel, to cross-examine the witness. You want to somehow also maybe give the feeling that you're imposing on that person. And it's very difficult. And I think the skill sets, and that has been actually said by many counsel, the skill sets need to be changed. You cannot have the same aura that you usually have in the hearing room when you are cross-examining a witness. You have to switch your mind, but you have to, in my mind, make it as close to the real thing and physical cross-examination as possible. So one tip, if I may give, but I thought it really makes a difference, is in cross-examination. When you are showing the witness a document, what happens is that we go on the screen, or our document manager who is assisting us goes on the screen and shares the document. So everyone sees the document. You highlight or go to the passage in order to make the witness feel comfortable with the passage that you are referring to, be it, for example, the expert's own expert opinion, and looking at that. And I think a cardinal mistake here would be, in that moment, to pose the question. The really effective way would be to then close the document, so do not share it any longer, and have the witness back on the screen and then pose your question. And I think it is delaying for sure, because you have this change of sharing and so on, but you have, again, this looking into the eyes, if you will, between counsel and expert. And this replicates a little bit the situation that one would have in a hearing room. So while we are actually quick in changing screens and sharing documents on the screen, we should take our time to really look into the right camera, first of all, and also then try to fix the expert's attention by looking at the expert directly and not letting the document still be on screen at the time when one asks a question. So that would be my one tip of the day for cross-examination by video conference, and where we have to be, as I said, we have to be patient with ourselves, to take one moment longer, but still then hopefully be as effective as in a physical hearing.
Thank you, Nyusha. I think that was very useful on a general level and then on a practical level. And I think your conclusion that this is basically requires us to work on our skill set and our self-awareness. How do we communicate? It's very important because the environment has changed. I would leave it with that, and I would move to the next set of questions for evidence and oral hearing. And you have already mentioned document production and witness cross-examination and witness statement. And that being said, if we can start with Omar talking about checking the whether the witness statement is authentic, and then if you can, Nyusha, also reflect on other documents, whether they are authentic, and how to address cybersecurity when it comes document production. Omar?
Thank you, Patricia. I'll try to be brief on this. I believe at least what the Mexican community have made in order to be certain about the authenticity of the witnesses will be, one, whenever it is possible due to cost, use this kind of cameras that provide 360 kind of reach, and that will basically ensure at least that, one, the witness is alone by himself, second, that it is not coached, and third, that will basically be in the position to provide the answers that the arbitration tribunal is seeking for, or the parties through cross-examination are seeking for. A little bit more rudimentary, but sometimes I have seen Mexican arbitrators just in the custom or the practice that we have in our courts, basically to ask the witness to approach and basically to provide the ID just in front of the camera in order to say, you know, I'm the same guy that says my passport or my driver's license. Third, I believe that we should not underscore enough the importance of the declaration to be provided in truthful basis. We know that there is no perjury for a witness to declare, at least in Mexico, to declare false premises before an arbitration tribunal, but I believe the arbitrators in Mexico, and of course opposite parties, are skillful enough in order to try to show whenever a witness is basically lying. I would recommend strongly also an article edited in a book called The Evolution and Future of International Arbitration, where Gloria Alvarez was also participating in somehow. This was edited by Stavros Brekoulakis and Julian Liu and other very high respected scholars. And there was a time where he envisioned 2016 that eventually there will be these fMRI lie detectors lenses that show, or in a way, they look a little bit futuristic, but now, having seen what it is happening nowadays, I will say that there will be the time where this kind of technology tools will also be useful. I wonder whether those can work in a Zoom situation like this. I guess they do not, because they require to read somehow telematically the blood pressure and so on and so forth. But I will not put that excessive weight on the declarations of the witnesses, but rather in the preventive measures that party counsels can also take in order to ensure that basically the written statements of these fact and expert witnesses could provide, and not to be excessive into the kind of directions or assistance they can provide. And in that regard, the IBA rules regarding party representation, I think, will be helpful to be mindful for all practitioners whenever they provide some sort of assistance to witnesses. Thank you, Patricia.
Thank you, Omar, on such an interesting overview. Definitely a lot of details to take into account and considerations. Nusha, would you like to proceed and picking up where Omar left?
On documents now. I understand the question is about documents within the framework of a virtual hearing or remote hearings and the
That's correct.
So Omar mentioned already the OWL, or the 360-degree camera. That, of course, can also be used when one wants to ensure that the witnesses are not using any other documents and are not in any way other, of course, being unduly. But in terms of cybersecurity, so I think one thing needs to be understood that like this meeting that we have right now is being recorded, and so the platforms that are offering this video conferences or hearings remotely also offer a recording of the not only of the audio but also of the video. And when it comes to documents that are especially that are shared, then I think we have to be careful whether we really also want to share now that we have it at our disposal, the video of the hearing, or we do it like in physical hearings. At least most of them, I don't know how it is in Mexico. I understand in South America, they are often also taking videos. But at least I know also a lot of hearings where usually there's only a transcription and there is not a full video taken. And so one should consider first whether the recording should be done externally or actually on the host's computer, and the video recording, which then also would show the documents. And then as a second step, whether actually the video should only be kept by the host, so it can be the tribunal, or if it is a platform provider, the platform provider, which then actually gives it then to the tribunal, but then deletes it from the platform or from the cloud or whatever they're using, in order not for this video to be duplicated furthermore. I think that's a point that might sometimes be overlooked, that when it comes to documents and virtual hearings, we have to also consider that it's a video recording behind it. And so my recommendation would be to limit it actually only to an audio recording and a transcription that happens with AI or with humans behind it, but to be very careful with circulating the video of the hearing as well, precisely in order to protect potential or confidential documents and information.
Thank you very much, Nusha. Again, many considerations and things to take into account when it comes to cybersecurity and confidentiality of documents, but also we will talk about virtual hearings now as well with Claire. Omar, in that case, the question would be regarding the logistics of virtual hearings. If you could sort of advise us for the parties how to present their arguments and basically how to handle these complications possible in virtual hearings.
Right. As mentioned, I believe this is a work of collaboration between the parties and the arbitrator. There are a lot of things that can go wrong. For instance, poor connectivity, technical breakdowns. I can imagine that if all of a sudden there is a storm or there is a problem, I don't know how it's in England or Belgium or elsewhere, but in Mexico, very frequently we have this problem where you are disconnected, or your connection is unstable, or the parties cannot hear you, or so on and so forth. Then when those kind of things happen, I believe the importance of prevention, preparation, and testing through the instruction of the arbitration tribunal will be paramount in order to avoid, or at least foresee, what you can do in those scenarios. Those are the kind of things that could be within the context of a challenge, the kind of things that a Mexican court could say, well, if for some reason the hearing took place and there was no possibility for the other party to connect, then, and you as an arbitrator did not rearrange for the next day or so, then I believe there could be the fundamental rights of a hearing could be undermined for purposes to vacate the award or to deny recognition and enforcement. I will say preparation, flexibility, and prior testing will be probably the kind of words you will be listening a lot from party counsels and arbitrators in order to try to diminish the possibilities for something to go wrong. I will also underscore the fact that the secretary of the tribunal will play a much more active role than before. I will say that if that secretary, usually young people, are or is very able and capable to have technical knowledge in order to assist the arbitration tribunal, will be great. But otherwise, I believe that that technical secretary or the arbitration tribunal itself will have to be joined by a team of persons that will be capable of resolve IT problems. But flexibility, good faith of the parties, of course, because at the end, this is a gentlemen's and ladies dispute resolution. Therefore, there should be some sort of flexibility in those kind of troubles, and be able to try to take this case to basically to the stage of the decision-making process. In Mexico, it's very customary that at the end of a hearing, even a remote hearing, there is always a question to the parties as to whether or not they were treated fairly and they were not impaired, or they had the right to present their case in the hearing. And in 27, 28 years of experience, almost all the times the answer has been yes. And if not, and if there is a qualified answer, there is always a possibility to say, well, what has it happened that you are not comfortable with this? And usually the arbitration tribunal and the parties are able to accommodate in order to override that kind of challenges. But that's what I can say on this, Patricia.
Omar, before we finish this session for today, I just wanted to, on behalf of all my colleagues, including Nirsha and Claire, who are also our guest stars today, I wanted to say thank you very, very much. We thought about you because we all know personally that you have taken the leadership on this conversation in Mexico. And Mexico, as many other jurisdictions in Latin America, are very important to be considered, not only, what's happening in Europe, but how we are managing with this, because actually in the region, we have seen, and we will continue to see a lot of disputes, particularly arising from 2022, and the future with technology is going to be particularly interesting for us in our region. And you have taken that flag very well. I have seen all your hard work in the last few months. We wanted really to say thank you. We thank you also for supporting us throughout all the year in these seminars, and to come and Aberdeen and Jurídicas. And we send you a very warm hug, and we hope that you're still a friend of this initiative. And thank you so much to you.
Big hug to all of you. Thank you for all your academic and practitioners' efforts, and I'm the one that is honored and pleased for your invitation. Thank you all.
That brings us back to Claire, and to continue now on the question of virtual hearings and confidentiality and cybersecurity. I would like to connect this question to one of the questions that was asked by one of the audience members. Is there arbitrator liability if the arbitrator was negligent or applying proper cybersecurity measures? In other words, if arbitrator contributed probably to the breach of cybersecurity or confidentiality, but maybe even to pose the question even broader, is where should liability lie in the end? And having, again, taking into consideration what Nusha already mentioned about video conferencing and so on, if you could give us your insight on the topic about cybersecurity and confidentiality.
Thank you, Patricia. It's a very good question. It's quite complex, but I'll do my best to address it briefly. I think there are two potential ways in which an arbitrator can be liable for a security breach. The first one is if there was a disagreement between the parties about what measures should be taken. So as you know, many institutions are now going towards the view that cybersecurity is very much a question for the parties and arbitrators to deal with. So if at the outset, for example, at a case management hearing, there is a disagreement between the parties as to a cybersecurity measure, the arbitrator has to rule on that, on the risk and what measure is needed. Let's say they come up with a view, they embody this measure in a procedural order. What happens if ultimately there is a data breach and it turns out that that measure was not appropriate? I don't want to scare people, but I think it's important that we think about that. Why? Because arbitrators' function is to resolve the disputes on the merits, and their powers relate to two things: deciding the dispute on the merits and procedure. And I don't know if you know, but I've been writing a lot about this. The problem with cybersecurity measures is that they're actually not entirely just procedural, they're not entirely just administrative in nature. If we say that they're all administrative, then it's not for the arbitrators to deal with them, it's for the institution. If we say that they're procedural in nature, then that's for the arbitrators. In the Arbitration Act in England, I think it's similar in most jurisdictions, the immunity of arbitrators is going to be limited to their powers. So potentially the arbitrator's immunity does not extend beyond the procedural aspect of the case. So if the problem here is a question of administration, potentially arbitrators actually do not enjoy immunity when it comes to ruling and deciding on a cybersecurity measure. So I think that's the 1% potential scenario where an arbitrator could be liable, and actually there wouldn't be immunity for that potentially. The second scenario is where there is a cybersecurity that's in play. It's in place. We don't know if it's in the rules or if in a procedural order or in a contract, terms of reference. We don't know, but there is a cybersecurity measure in place, and the arbitrator, for some reason, does not abide by it, and as a result, there's a data breach. Now, I'm not saying that a data breach will always result from a failure to comply with a measure. I'm completely aware of the fact that it could simply happen, and we have no idea how. But let's say that there is a measure in place and that an arbitrator does not comply with it, is negligent, just doesn't follow it. And as a result, there's a data breach. What do we do then? I don't think the immunity bites here either. If the measure is in a procedural order as opposed to a contract, it's quite tricky because obviously it's almost like the judge trying to determine who's made a mistake when actually the judge made the mistake itself. So that's an issue. So my view is that it's better to embody a cybersecurity measure or cybersecurity measures in a contract as opposed to a procedural order. And I'm talking here talking kind of on behalf of parties, arbitration users, and counsel. Because I think it would be easier for a party to enforce a measure, a cybersecurity measure, against an arbitrator if it's in a contract. If it's in a procedural order, it'd be a lot trickier. So I've been writing about it. I think it's important to think about those issues, and there's different ways in which we can come up with a contract. It can be, as I said, terms of reference, terms of appointments, or simply just a cybersecurity agreement. The beauty of that approach is that you can extend it to whatever participants you have in the arbitration. Unlike a procedural order, which is generally limited to parties, a contract could be extended to subscribers, translators, providers of platforms, anybody, whether those people are involved in the arbitration secretly. Lots of parties use providers without having to disclose them to the other side. It's fine. You don't need to say who's translated your pleadings or. But with a contract, you could just simply, parties could be obliged to have anybody taking part in the arbitration sign up to those rules, to this contract, before they can engage and effectively access arbitration data. So that's my answer. I think he kind of, it's what I wanted to say in one way or another about virtual hearings. Although I guess cybersecurity has always been there. Maybe I should simply say that with virtual hearings, what happened is that arbitrators and parties had to act very quickly. So they didn't have the chance to consider those new issues. And I just wanted to come up with one example. I know some arbitrators were not comfortable using the hearing platforms to discuss during the hearing. At the hearing, arbitrators very rarely write on documents and pass messages, but they whisper in other arbitrators' ears. Of course, you can't do that in a virtual setting. So I'm aware of arbitrators setting up just simply a WhatsApp group to exchange during the hearing, because they were nervous that if they used the chat function of the platform, they would, those messages could inadvertently be shared with parties or counsel. That would be, of course, dramatic. So, but of course, WhatsApp is generally seen as not secure. I'm not an expert, but based on what we see in the press, there are definitely issues with WhatsApp. So, I think it just shows that because of the speed in which arbitrators had to adapt, there were therefore some areas that were kind of left and not considered in terms of cybersecurity in virtual hearings.
Thank you, Claire. Again, a list of considerations to take into account. We started rather positive and sort of ended, with a list of things that we need to check in advance when we are conducting any part or full hearing or arbitration proceedings virtually. Again, a very, very good points were made. And now I received the green light from the organizers to ask one question for the last set of questions, sort of to light up the mood after all these long lists of considerations and to sort of take a look into the future of arbitration. Unfortunately, Omar left, but he did mention using biometrics, biometric-based cameras, sort of to read the expressions, emotions as a lie detector. And this is a great introduction to our last topic of the day, which is AI or artificial intelligence, because biometrics is AI-driven as well. And sort of a general question to cover different points, and I would start with you, Claire, would be to what extent we are already using artificial intelligence in arbitration to assist arbitrators, and then if you could give us a sort of, visionary look into the future, what do you think, how will that develop, and to what extent we can expect technology to actually become quite helpful in that regard? And then, of course, Nusha, at the end, if you would like to add anything up, I would be very thankful to hear your insight as well.
Thank you. So in terms of what the current applications of artificial intelligence, I think there are two. One of them I can talk to. The other one I'm not so sure. So I'll start with the one I'm not so sure. I think that search tools already embody some artificial intelligence. I wouldn't say tool, because I think most of the time the user is not aware of them, but they're kind of built into the search tool. And so I think perhaps without knowing, we already use AI in arbitration where we do legal research. The second one is a conscious one. So you've got to know that you're using it if you are using it. The problem with this one is that at the moment there's no regulation whatsoever as to whether you have to tell the other side if you're using it, or the arbitrators. And I'm talking about predictive coding. So predictive coding is a form of machine learning, artificial intelligence, by which documents, both relevant documents or in arbitration documents responsive to document requests, those documents are identified not only or not by way of search terms or date ranges, but by an algorithm. This is something that a lot of teams are using in both litigation and arbitration. I'm not sure about Mexico, but I know that in the US and in England, it's used in the courts, and it's very strict. How you have to use it, whether you have to disclose it to the other side, how precise the algorithm needs to be before it's applied to the whole set of documents, etc. In arbitration, we don't have such regulation, so I think this is something that the arbitration community needs to start doing and think about, because at the moment we are lagging behind litigation, which is really a shame. When it comes to the future, I think Omar is right that I think artificial intelligence is probably going to be used at some point to assess the credibility of witnesses. And I wonder if, at the end of the day, ultimately, this could actually mean that we don't have evidentiary hearings whatsoever. Maybe a kind of a nice kind of way of looping in that last subject with the virtual hearing subject, is that if we can just have a witness reading their statements and having a machine telling us where the lie is, why don't we need a virtual hearing or in-person hearing and cross-examination? I think there's two more ways in which artificial intelligence are going to be used in the future. One is there's probably going to be some tools to predict outcomes. And of course, the big challenge with that is to have a sufficiently broad body of awards available. And the second one is to identify potential arbitrators. I think potentially we could use artificial intelligence agents to really pick and find the best candidate for a particular case. And I think that's what Professor Rogers is working on with her arbitrator intelligence tool. So those are my thoughts.
Thank you very much, Claire. And I have to say, you're completely right. We have machine learning and artificial intelligence all around us, and we are probably not aware. And I'm so happy that you also predicted possibilities and opportunities for us to actually deepen this assistance that we can receive from softwares after the whole evening or the whole conference, in my case evening, talking about the issues. I hope at one point we will get to the point where we can actually think about the possibilities we have with technology that we haven't had so far. And that brings me to Nusha. If you would like to add something and follow up on Claire's points and share your thoughts and insights regarding the future of AI in arbitration.
Yeah, so one thing that AI is doing already, I think, as well, is translation and transcription. So we have AI technology that is assisting these tasks. And in fact, and I personally came across this only at the beginning of this year, once we had our whole rush to the virtual hearings, but maybe it existed before. It's also AI-assisted interpretation. So we are in a setting of a virtual hearing, and we have witnesses that are giving their testimony in a language other than the language of the arbitration proceedings, and AI helps, and they have been used already, helps in interpreting the witness. You can choose, is it female or male? You can choose and if it's to English, is it US English, Australian English, or is it British English, whatever it is. So it's already there. So that is something I think that we will see more, because it does help the transcription, interpretation, translation. It will help the whole process to become cheaper and more effective. That's my take on this. Then on a predictive outcome, that is indeed something that we will see eventually. The problem is the data lack. And so because we have confidentiality, we have cybersecurity, we have data protection, we have all these barriers cocooning the arbitration procedure and also the award, then which will hamper actually using this data freely to create the algorithm for a predictive outcome. And that's where Claire is absolutely right. Litigation is so much more advanced because the wealth of the data is so big. It's not you cannot compare it with what we have there. There is this sorry, I need to check the name, dispute resolution data. So it's an initiative that is actually collecting commercial arbitration awards and also mediation settlements, but they are at this moment only using it for statistics. I don't think it's really going into AI right now, but it's fantastic that they're collecting this, and they have partnered already with institutions. So that is very good. I think when it comes to predictive outcome, you can probably see, if at all, an advancement in investment arbitration before commercial arbitration, because obviously a lot of the awards are public, and also because maybe the issues at stake, the protections and the BIT are similar in the BIT. So that's something I think that we're going to see as well. And and about the potential arbitrator selection, that's where I am, to be honest, in two minds about it. I do believe, yes, that AI will also help, but I'm not sure whether the consequence will be a help for the arbitration community, and that is because I don't necessarily see yet, but I'm very happy to be convinced otherwise, how the pool of arbitrators can be expanded if we use tools like AI to make a selection on the arbitrator. Isn't it actually that precisely because we have the ability to use artificial intelligence for the selection of an arbitrator, we would actually maybe go more to the ones that the outcomes are predictive, or at least they are a little bit more clear, and how they always deal with document production, generous or not. Do they look at materiality and relevance only, or also at the burden of proof? So what is, with the consideration? So I think it can at least have also the opposite effect of rather limiting the pool of arbitrators than expanding. So because if I don't know, Patricia, what your way of thinking is about document production, but I know that you're fantastic in the jurisdiction, then I would actually go only for that. But if I know you're very strict on document production and I really need documents from the other side, then I exclude you from the pool of candidates. So that's where I'm saying I'm happy to be convinced otherwise, but I don't see yet how it will necessarily help to expand the pool of arbitrators.
Thank you very much, Nusha. I agree in terms of ideology. I have not been yet very convinced because it can work either way, but we just don't know, how much it will grow, these sort of databases. So just to wrap up, because we are dangerously getting close to a very late time, especially for Nusha, who is the one that is latest from all of us. I would like to ask both of you, Claire and Nusha, what are your takeaway for this year, or your predictions with this acceleration from technology, indeed, or any other of the topics we have covered? What would you say has been your most important takeaway or lesson from technology and arbitration in the last few months, perhaps the last couple of years?
I'm trying to think of something we haven't discussed yet. I think it showed that we had to adapt quickly, and I think we did, as a community, we did pretty well. I think it's very encouraging for the young generation, because I think it shows that actually the youngsters adapt much better than the more senior arbitrators and counsel. This was very clear in virtual hearings. And I think it provides an opportunity. I think technology has always provided an opportunity to the younger generation. But I think even so more, even more now. Why? Because more technology, but also need to adapt. And I think it's very encouraging that we are realizing more and more that we need, those diverse team that have different background, different way of thinking, different types of knowledge. And I think it's been really great to work together and realize that the power of cognitive diversity and the younger generation. So yeah, I would encourage people to see what we've experienced as an opportunity. It's something I've said already about cybersecurity. I always thought that cybersecurity is an opportunity for arbitration to stand out from the competition and show that, for example, potentially arbitral institutions could be more cybersecure than courts, than national courts. It's been the same has been demonstrated for hearings. We've seen that now clients don't only consider the option of arbitration for the flexibility, confidentiality, and enforceability, all of those T factors, but also because we proved recently that we could go through and effectively weather out a crisis such as COVID-19. And I think we should carry on doing that for technology and see this as an opportunity as opposed to a problem.
I agree with that. I just want to remind you, maybe some of you were not even yet in law school. Back in 2005, there was this book published about the use of information technology in international arbitration. It's quite thick. It's published by Gabriele Kaufmann-Köhler and Thomas Schulz. And when you look at what they list as the technology that is used right now, back in 2005, you actually do see video conference. It is mentioned there. But one of the highlights is the copy and paste function, because it can create new documents in a very quick and easy manner. And I think if we look at that in 2005 and where we are in 2020, it's cute. It's actually quite amazing that what was considered IT use in arbitration at that time is now used by my 6-year-old son when he wants to put in on YouTube name of a video that he wants to see again. And so I think we are, because of the pandemic, actually we have made a big jump forward. We would have reached this, I'm quite sure, the same level of sophistication, even with its problems and data protection and cyber security, if there are, but it would have taken us maybe still another 8, 9, 10 years. And so this was an amazing potential for arbitration practitioners, for students, for everyone to actually jump on this wagon and be creative. And I think this is the quintessence of arbitration, to show its flexibility, to be creative, how to solve a dispute. But we should also, of course, consider that it's not only the mean how we solve the dispute that is important to the party. So it's not the procedure per se, but it's also the outcome. And what I saw in this year is that while we have sped up in the procedure, I still think that in the outcome, so producing the award, there is room for improvement. And that is when AI actually can help and new technologies can help, so that we are assisted in creating that outcome, that reasoned award that is necessary for the users to understand, to actually to speed up with that, or to speed up the pace on that level as well. And I think my bet is the sentence of the year will be "you are on mute," because we have heard it in so many video conferences, and today as well, I think 2 or 3 times. I'm sure next year there will be already a system on that immediately detects that I am on mute when I'm speaking. The microphone will hear that and will unmute automatically. So cheers to that.
Thank you, Nisha. You're totally right, and you make me your feedback allows me to connect 2 points. It is good to see how we have catch up with technology after what I will have felt like 2019, early 2020. We receive as arbitration community a lot of criticisms for different reasons, in the EU, to disclosure, etc., etc. But somehow we were able to retaliate with good practices in incorporating technology. And that's what you say, we have improved the process, we are good managers of the process, but we cannot forget how important it is, the outcome, the final arbitration award. And maybe that was a pending conversation we had from 2019. And, it's important now to see how technology can advance this further. I have actually, when I met Claire, in that conference, we were talking about an algorithm or an algorithm of EU law that could help all these exit arbitrators, for example. So, it's almost like a joke. But I do think technology, it has a lot of more fabric to keep cutting from. I have nothing else to say but to really thank, first of all, Patricia for her perfect, eloquent, very well organized and elegant moderation. Thank you very much, Patricia. It's a very dear colleague of mine in the University of Aberdeen. To Claire, thank you very much for the opportunity to visit us. Nusha, very good to see you. Congratulations again for your book, because actually Omar used the word acceleration, but you shape the word even better, and you use the COVID revolution and technology and arbitration with your very good book. So I have nothing to say, but thank you to all of you for your great takeaway. You might not know this, but this is the last seminar that we have of the year, after a very hard year of hard work, very successful seminars, and we really wanted to finish with the cherry of the cake, which is obviously both of you and Omar, who is not here. I want to also say thank you to Ana, to Silvia, to the Centro de Arbitraje de México, to UNAM, and we hope to see you next year, hopefully with more interesting seminars on more sophisticated topics. I don't know how we are going to overcome or find a more original topic than the one of today, but thank you very much, Nusha, Claire, Patricia, Anna, and Silvia, and obviously everybody who is joining us from their homes or offices. Thank you very much.